Prenuptial agreements are not legally binding in England and Wales insofar as on divorce a judge's jurisdiction won't be ousted by the fact that there is a prenuptial agreement in place. A judge on a divorce will always have discretion to look at the circumstances in order to try to apply fairness when it comes to dividing a married couple's assets. However, case law in this country, recent case law, suggests that we're moving towards prenuptial agreements having more and more validity. Therefore, provided certain circumstances have been met and certain criteria have been fulfilled, then there's a very good chance that upon a divorce, a prenuptial agreement will provide the basis of division of assets. Timescales for preparation of a prenuptial agreement can vary depending on how much financial disclosure both parties are having to gather, collate and exchange, and how long it takes the other party to go through all of that disclosure. However, here at the Law House, we make every attempt to have the agreement drafted and signed as quickly as is possible without prejudicing the quality of the agreement and the quality of advice that's being given. So in the usual sort of average circumstances, I would say that a prenuptial agreement should be completed from start to finish within about 1 to 2 months, depending on the level of disclosure. The benefit of a prenuptial agreement is that when you're entering into a marriage, you're aware of exactly what assets you would walk away with in the event of a divorce. Many people find that unromantic or a notion that's not particularly palatable at a time of engagement and wedding planning and so forth. But it is something that will provide you with certainty in the event that the worst does happen and you end up issuing divorce proceedings for whatever reason. If there is a separation in the future, you know that there's some level of certainty as to what assets you leave the marriage with.
There are various things that the courts will look at. The first thing is to make sure that the parties have received full and independent legal advice. So that is to make sure that the parties understood what they were entering into, and also that there wasn't any element of undue influence on the party, so that they weren't forced into entering into it. The other thing is to make sure that the parties give full and frank disclosure, so that at the beginning the parties will exchange documents showing what their financial assets are and what their income is, so that the parties entering into it are certain that what they might end up with on a divorce is going to reflect what the parties actually own. And the third criteria is to make sure that the parties have entered into the agreement in good time before they enter into the marriage. The recommended time is 21 days, but if the earlier the better, because that shows that the parties haven't been forced into entering into a prenuptial agreement.
There are certain criteria that have been identified by case law in England and Wales, and in circumstances where those criteria are met, the prenuptial agreement stands a much better chance of being valid on divorce. Those criteria are that both parties must have sought independent, appropriate legal advice before the agreement has been entered into. The second criterion is that the parties must have signed the prenuptial agreement in good time before the marriage. And the third criterion is that full financial disclosure must have been given by both parties prior to the prenuptial agreement being signed. That means that both parties must have been fully aware of what the financial assets of the other were at the time that the agreement was signed.